remember at the meeting.
Clock on the wall, 6 o'clock, so we'll bring this, this meeting to order of the Piqua Planning Commission, June 13th, 2013. Couple housekeeping things. Be advised that the Planning Commission acts as an administrative as well as an advisory council to the City Commission on matters specified in procedures adopted by the City of Piqua Code. Any with interest in speaking on an item should approach the lectern, state their name, address, and their interest in the matter at hand when time is appropriate. We ask that everybody that's here, please sign there's a sign-up list in the back of the room. That way we have at least a record of who all was here. How we're going to run things is we're going to review the minutes of the previous meeting, review any unfinished business, hearing new business, and then review other business and then adjourn the meeting. How it'll work is the staff will state the agenda item. They'll provide comments to the board. The applicant or agent can come up and provide comments to the board. Other affected parties then can come up and provide comments to the board. We're going to, since there's so many, we'll limit comments to 5 minutes. And we're not taking a vote or anything, so if you're just repeating something, please try and say something different or new or refreshing, so we don't just repeat the same things over and over and over and over. Other affected parties can provide comments. That's what we just said. Board members are then to comment and ask for any questions or answers. Then we will take an action, either approving, denying, or tabling the appropriate item. If there are no objections from anyone in attendance to the aforementioned meeting procedures, would everyone please stand and raise your right hand to be sworn in? Let it be known that all persons present to provide testimony at this June 13th meeting of the Planning Commission hereby swear or affirm said testimony will be the whole truth and nothing but the truth. All those in agreement, please say I do. All those opposed, please say opposed. Thank you. You can be seated. At that, we will start the meeting out if the staff would call roll.
Mr. Chair, City Planner French is ill today, so I will be filling in her absence. Mr. Bupp.
Here.
Mr. Harvey is absent. Mr. Wilson.
Here.
Ms. Brandon.
Here.
And Mr. Koenig also indicated that he would be unable to attend.
So that is a quorum, so we can conduct business. Meeting minutes from May 9th, we've all had a chance to review those.
Mr. Chair,
Yes.
we need to excuse the,
Oh, I'm sorry, yes. We will excuse those two that aren't present. They had excuses, including a vacation for which I'm jealous of why they're not here. So if that's approvable by the board, please say aye.
I'll make a motion to excuse the 2 members.
Second.
Okay, all in favor?
Aye.
Aye. So they are excused. So that is a quorum. We can do business. We've all had the meeting minutes of May 9th. Is there any corrections or adjustments to those minutes necessary?
I'll make a motion to approve the minutes.
Second.
Okay, all in favor?
Aye.
Aye.
Aye. So minutes from May 9th are approved. So that leaves us with old business, which I don't think we have any. At that point, let's go ahead and do new business. If staff would read the resolutions.
Resolution PC 19-23, This is a resolution requesting a special use authorization for an expansion of a non-conforming use vehicle repair located at 219 Spring Street in the traditional general mixed use district.
Is the applicant or the applicant's agent here to provide any comments for that resolution? So please come up and state your name and address.
My name and my address?
Yes. I know mine, so,
Well, I didn't know my address I live at or the address of the property. So it's Jeremy Town. It's 224 Jackson Street. It's in Piqua.
and your name?
Jeremy Town.
Okay, what can you tell us about this resolution?
Well, really, it's not anything new that we're doing. We're just branching off into the back side of the building that we're already been working into. I talked to Kirsten, and she said she'd have to bring it in front of you guys to okay it or yay or nay it.
And I apologize, she's ill, so she couldn't be here tonight,
Yeah,
so.
I sent, while I was doing stuff with her, I sent her pictures and everything of the building and how it's laid out. I don't know if she,
We have all that.
okay, all right.
We have all that.
Yeah.
So this is across from Lock 9, basically, is what you're talking about.
Yeah,
Yeah.
yeah. So, and it's not just a vehicle repair. Like, we actually don't do a lot of vehicle repairs. We do a lot of custom car work on classic cars, interior, exterior, audio, all that stuff inside there.
Is that mic on?
Yeah, it's on.
Okay,
Yeah.
good. She had several items of concern, and I assume she went over those with you.
Some, yeah, but I guess you can lay them back out there for me.
Okay.
Yeah, the conditions.
The conditions that she placed upon this resolution is that no more than 4 vehicles will be parked for storage. No work of any kind will be done outside.
Yeah.
No junk vehicles stored on the property for parts or whatever, you would be doing that. Doesn't sound like you're going to do that kind of
No,
business.
actually, these are all things that I laid out to her that we would.
You laid these out?
Yeah, those are all things that I can.
Let me just go over them so we enter them in the record here. The parking lot would be resurfaced and striped within 2 years of this application.
That's in contentions of the apartments being completed, because we don't want to do that to the property and you guys drive equipment across those while you're doing building there.
Understood. That's probably why the 2 years is there instead
Yeah.
of just 1. Decorative screening be installed on the property within 2 years, so between your property and the adjacent housing.
There'll be an area that we have that's a concrete pad where those said 4 vehicles, if we have any there, they will be behind the screen there.
Okay. Vehicles, no vehicles can be double parked. The drive aisles must be maintained.
Yeah.
Exterior repair of the building as proposed in the attached drawings that we got. Window boxes and new signage for the building exterior will be completed within 2 years. The dumpster will be removed and in its place elsewhere in the lot. You're going to have a screened dumpster area, I
Yeah.
saw.
Yeah.
And I think that's the conditions she has listed. So I would say that we would include that as this resolution. So any other parties wish to speak on this issue? Thank you, by the way. If we have other questions, I'll give you a holler.
Okay.
Thanks. Nobody's jumping up. Any questions from the board or any answers we need answered?
Just that the screening proposed will be to the south and to the east, so that'll protect the residences to the east, and then the proposed condo to the south will have that screening, so it won't interfere with that. So I think that's what that's all about.
And we're talking like a landscape
Yeah.
shrubbery kind of screening.
Right.
She offered
I don't mean around the dumpster itself. I was talking about between the two.
Separate the properties?
Yes.
Well, on the east side is an alley. On the south side is going to be an alley also. That's in your guys' plans for that apartment, for them to come in the backside of that alley. So there'll be an alley separating the property.
So you were understanding that that screening was just for your dumpster?
The screening will be used for our parked vehicles that we have there, and the dumpster will be in that area also.
Yeah, you guys read it as well?
No, I didn't do that, hear that.
I didn't either. I kind of thought it was a separation between your property and the adjacent properties
Yeah, it says
around that.
east and south. So,
When I spoke to her about it, it would just be that area that we have the concrete pad on. For us to put a barrier of some sort, whether it be plant or whatever, you want that along the whole length of that parking lot all the way to Spring Street from the back alley. That'd be the south side.
yeah, towards the condominiums, the way I read it, that would be a barrier between the two. Of course, I don't know what you two had talked about, but I took it as residential to the east and then condos to the south.
Mr. Chair? May I?
Yeah, Vice Chair.
I believe the staff report indicates what the applicant is stating, that, and the applicant, I think, is saying the same thing, that there would be screening behind the concrete pad and then along the south edge of the concrete pad where the vehicle storage would occur.
So we wouldn't need to come all the way forward.
But there wouldn't necessarily be plantings. It may be a wood fence or structure of that variety. So because of the limited space, I doubt there will be planting in there. So either way, we'll work with the applicant to make sure that the
Yeah.
screening satisfies the
Yeah.
development standard.
I'm okay with
Yeah.
either way.
It's fine. Screening.
Run something all the way down there, it would look kind of silly.
Okay. Any other questions from the board? Can we entertain an action?
Yeah, I'll move to adopt resolution PC 19-23.
I'll second that.
Okay, let me read my bylaws here. The planning commission has reviewed the application and it will be compatible with the intended use of the real property. Will not threaten the general health, safety, and welfare of the surrounding properties, and the adjacent property values will not be affected negatively. Is compatible with the general economic development policies of the city and conforms to all other applicable plans, policies, and regulations of the city. So at that, let's have a vote.
Mr. Wilson?
Aye.
Ms. Brandon?
Aye.
Mr. Bopp?
Aye. So, what resolution was that?
1923.
19-23 is approved. Going on, 19-24, right? 19-20-23.
20-23.
Trying to look on my phone here, guys, apologize.
A resolution requesting a zoning designation of an IL, light industrial, for approximately 119 acres to be annexed, being parcel J27045-800, approximately on the corner of Looney Road and Snodgrass Road. Mr. Chair, this item comes before you by way of the property owner's interest in annexing the subject tract of land, which is contiguous to the current corporation limits along Looney Road, just to the northeast or northwest of Indian Ridge subdivision development. It is the same owner who owns the subdivision, who owns this tract of land. Their interest is to annex this property to facilitate light industrial development, similar to what you might see on the other side of the road along Looney Road as you travel north of 25A. And so as part of the process, before the annexation petition goes to the city commission agenda for their final action and acceptance of the annexation, the planning commission is asked to provide a recommendation for the appropriate zoning designation upon annexation. Staff has reviewed the request with the applicant and agrees with the applicant that a light industrial zoning designation would be suitable and appropriate for this property. I would note that in that district comes some buffering and screening type requirements in terms of landscaping that would mitigate any concerns that might arise depending on future site development activity as it relates to the residential to the east and south.
Does the applicant or the applicant's agent have any comments for the board? Are they here?
I believe he's on a mission trip.
Wow. Okay, any other affected parties want to ask questions or comments on that, this resolution? Any questions? Okay, go ahead. State your name and address.
Mike Haynes, 9391 Looney Road. I guess I'm just curious exactly what's going to go in there. What kind of light industrial? Is it going to be a lot of semis going past the front of my house, or what is this?
Well, I don't think we know, there's nothing planned that I'm aware of. It's just the designation at this point, and then once it's
He just wants
designated.
it rezoned so he can do
Yeah,
something with
and
it.
then at that point, they'll try to see what businesses they could get to come in, but as of right now, there's no planned businesses going in there.
Do you have the definition of light industrial in the current new code, Chris, handy?
I do. So to the question, there is no imminent end use. The interest is to be able to annex the property to make it more attractive for development potential and be able to access utility services. Within that zoning district, uses that may be permitted by right include items such as nurseries, offices, vehicle sales and rental, low and moderate impact industrial uses, vehicle service, warehouse and distribution. Other uses that could be considered as a special use include indoor recreation, outdoor recreation, self-service storage, car wash, fueling station, and a university campus, which would be pretty unlikely there. The other part of that is, as I mentioned, with screening and buffering requirements, part of the review of any site plan submittal that would come forward as a result of the zoning and the ability to develop it would be looking at the potential impact that the use might create. So if there's an increase in traffic, making sure there's a traffic plan that's included with the submittals to understand how those vehicles will route to and from the site so that they don't cut through the residential neighborhood or otherwise have an adverse impact on the surrounding properties. But certainly something similar to the light industrial uses on the other side of the road would be conceivable, which I know there is a trucking distribution operation over there. So I wouldn't say that's out of the question, but if it were something that was going to produce a high volume of trips, generate a lot of trips, that's something the Planning Commission and or staff would review as part of the site plan review to make sure that it's not going to be excessive.
That's my concern, is that there's a lot of semi-traffic in front of my house now. I just want to make sure that that's not going to continue and get worse. That's all I have to say. Thanks.
So to kind of sum that up, it sounds like individual plans then would come before this board again. So there'd be a opportunity to make comment as, at that time, we would know exactly what it would be.
I'm sure I'll be notified by mail just like I was.
You were, right? Yes. It's same thing. And usually all the neighbors have to be notified of anything like that. Anybody else? Let's entertain a motion then, if we don't have any other questions on the board.
I'll make a motion to approve PC 20-23.
Second.
Okay, let's, Chris, if you could take the roll there.
Ms. Brandon,
Aye.
Mr. Wilson,
All right.
Mr. Bupp.
Aye. So PC 20-23 passes. Let me make sure we have checked all our boxes here. The proposal's compatibility with existing land use plans and policies are not a negative. Traffic impacts and changes. These are some things that would be considered as we look at individual light industrial uses that would come again before this board. Potential impacts to historic assets, changes to impacts to the enjoyment of the property by neighbors, the ability of the city to serve and propose development with water, sanitary, stormwater, electric, and other utility infrastructure, and the city's ability to meet the public health and safety needs of the development. So with that, the motion 2023 is approved.
Mr. Chair?
Yes.
Before we start the next item, I think there are some people in the hallway, if we want to give them a minute to come in, if they'd like to come
Yeah.
in.
Anybody standing out there, and has everybody signed the sign-in sheet?
You're sitting on it.
Oh, that's not good.
It's recorded, so we're okay. It's okay.
You all right? Chris says okay. Let's go on then to next proposal. If we could have clerk state or the staff state the agenda item. Well, first, before I assume most of you are here to speak or comment on that individual item. Are you here for the last item,
Which would be?
the annexation?
No.
Okay. Since there's so many, we're gonna limit the amount of comments to 5 minutes. And again, please, we're not taking a vote or a straw poll or anything. So if you all you're gonna do is repeat what has already been said, think of something in addition to that to help out the situation. So at that, let's go ahead and, staff, if you would read 21-23.
A resolution requesting a recommendation for the adoption of a new ordinance, Chapter 109, rental registration. Mr. Chair, on April 24th, there was a work session, joint work session with City Commission and Planning Commission, at which time there was a presentation provided outlining the origins of this item, which really go back to the 2007 comprehensive plan update, whereby there was information received through stakeholder engagement conversations and the like that really recognized the need for there to be some mechanism to advance or ensure that housing stock, rental properties in particular, were being maintained in accordance with the code requirements. Following the public hearing or the work session, the information presented at the meeting was posted to a website. That link was advertised to the public, and a public comment period occurred for a period of 30 days. And, the link went down just prior to the end of the 30th day. We put it back up to provide other individuals additional time if they so choose. But through that link, we received 24 comments from 16 different individuals. 2 of them were duplicates, so really 23 comments. And I would characterize those comments as one that was primarily interested in the utility provision that was discussed at the meeting. 2 that were for the proposed rental registration, 12 that were against, and then 8 that were simply making comments or asking questions. The comments that were received has been printed out and are in front of you this evening, and those will be made a part of the packet as it's advanced to the City Commission. We did redact the individuals' names and contact information to maintain some level of privacy there. So with that information provided, knowing that you all heard the presentation previously, the real crux of the item here is to create a rental registration process, whereby once each year, the 4,000 or more rental properties would be required to register, providing some basic information about the unit that they're providing or allowing to be used for rental purposes. And then that information would allow us to assimilate a database that would be used to inspect or attempt to inspect each of those properties every 3 years. There's some provisions in the statute that describe the criteria that needs to be satisfied for the registration process to be complete, which would allow then for the issuance of a license, which is an annual occurrence. So upon issuance of the license, the property would be permitted to be used for rental purposes, and then also be subject to the inspection requirements. It's conceivable, although it might be a bit challenging to be able to think that we can get to all 4,300 some properties every 3 years, but that's the objective at this point. Also in there is language about the fee, which is $65 annually. It's a flat fee that would be collected at the time of registration, and that would offset the cost of running the program, the inspection services, and the incidental cost associated with doing that. A couple small changes to the draft ordinance that was originally posted, and some of this was based upon the feedback received. In the first section, we added some clarification about land contracts and that they are subject to this provision. And then also, under the submittal requirements, there was previously some language about submitting a sketch of the floor plan. That has been removed in favor of, as part of the application, we will simply ask some basic information about how many bedrooms and total square footage, things of that nature. So it won't imposition the property owner with having to come up with a floor plan or create a sketch. And then finally, there was discussion at the original presentation about the issue that we continue to face with unpaid utility bills when renters leave the property and fail to pay make their payment on the obligations they have. So originally there was discussion about having the owner having to guarantee that payment would be made or received by the city. There was a lot of concern over that, so we've modified the language there, taking that burden off of the owner, if you will. There's no guarantee being required, but there is a provision for the license issuance that would require that there be no outstanding or past due utility bills associated with that property. So if there's past due utility bills that are unpaid, then the license wouldn't be issued. So that's the change. Those were the changes that are made, and that's why you have a new or an updated draft copy in front of you this evening, which is dated with the date the changes were added. That'll be posted to the website as well. But by and large, that's the gist of the program. This is in addition to other code enforcement activity that's been ongoing for several years now. This just really attempts to focus on some of the concerns that we've heard for many years about the condition of rental properties. And there's some data that we shared as part of the presentation that comes right from the census reports that speaks to a number of homes in Piqua that lack basic facilities, which is concerning in and of itself. But then the other information that was presented was some of the conditions that are observed when the tenants invite the inspector into the home. And certainly not all 4,000 some properties are of those poor conditions, but there are some out there that are simply unsuitable for occupancy and unsafe for the individuals living there. So that's really the objective of this ordinance, is to remedy those conditions and eliminate that the unsuitable housing conditions that may be out there, so that we don't have persons living in those conditions. So happy to answer any questions as best I can. This is really, again, just a public forum to receive public comment. And then the ask of the Planning Commission would be to make a recommendation to forward it to City Commission for their consideration. We understand there's a lot of interest, and there's a lot of individuals that have personal feelings about it. And that's why we will continue with these kind of comment forums in addition to the public comment forum that was already conducted.
I have a question. I've kind of been following this myself, and one of the things that I think is I'm going to say a sticking point is the right to the renter's privacy. and I think it boils down to how inspections occur with respect to the renters. And if they're given adequate notice to ensure their privacy, according to the Fourth Amendment. And that's kind of what I've read into a lot of this boils down to, and Frank, you might want to help us if you would too. I think there is a point there where, you know, I don't rent, but I can see not wanting to just have my home be opened without my knowledge of, not that I have anything personally to hide, but just the you know, the idea of it, let my cat out, stuff like that.
My understanding how this is going to work is that the code enforcement officers are going to contact the landlords and make arrangements to inspect their premises. Under the revised code, every landlord has a right to notify their tenant and then with a 24-hour notice to enter into the premises for inspection purposes or whatever. If the tenant refuses, it's not going to, the city folks aren't going to put themselves in harm's way. What will likely happen in those cases is that the code enforcement officer will let and we hope the landlord attends these inspections, that they'll inform the landlord that, hey, we weren't allowed access. You're not going to get your permit until we do allow access. If you rent without a permit, that is a criminal violation and you could be charged. So you have a couple choices in that case. One is to talk to your tenant and say, look, you know, you've got to let these folks in, or you can evict your tenant and evict them and then rent out to tenant and have it inspected and then rent it out afterwards.
So from the city's standpoint, you're making allowances for them to coordinate a time, the landlord and the
Yeah, I don't think
renter, to coordinate a time that they agree that we can go in and make our inspections.
Yeah, I don't think it's possible for us to just go knock on the door and say we're going to inspect it.
Right, but I think that's what I
Well,
read a lot of people were kind of worried about.
Chris will be in charge of the logistics much more than I am, and my understanding from the meetings I've been in is that they would contact the landlord, talk to the landlord, say, hey, we want to inspect these premises, will you let your tenants know? And then we'll meet them at a certain time, is that correct?
And from what I read, the landlord gets 2 notifications before anything proceeds.
Yeah, it's actually, it's spelled out in Section G under 10905 in a fair amount of detail. And what it says is that through the registration process, we'll have contact information for the owner or their agent, and they will be notified that that property is up for inspection, and we need to coordinate and schedule a time for when that can happen. Ideally, the owner or the agent would join the inspector at the inspection, and that's our desire. That's how we intend to try to operate it, understanding that too can be a burden or an inconvenience on the property owner as well. So we'll have to see how that works out, but the scheduling is not just a knock on the door, hey, we're here. It's a coordinated, scheduled time with the owner of the property.
That's exactly how I understood it, but it's good for everybody to hear that, I think.
Sure.
As that seemed to be the biggest issue from the tenant standpoint that I read into the thing.
If a tenant refuses and a landlord doesn't want to get involved, the landlord certainly can look at us and say, hey, will you just get an administrative search warrant? We can go to court and we can request a search warrant and enter that way, but that really is not our desire to do that. Whenever you do a search warrant or something of that nature, it puts the people at risk and harm, and we really don't want to put our folks in that harm or in that way.
Quiet, please. Okay, any other questions from the board for staff?
I have a couple questions. So the code that the inspectors, that you're using, Is it the International Property Maintenance Code through the ICC?
Correct. And if, in your packet, you may have noticed there's a checklist that's been created that really kind of deduces the different sections of the code down to the basic elements or descriptors. So that checklist is dual purposes. One, it's for property owners to know, here's the things that are being looked for. And two, it's a quick reference guide, if you will, for individuals who live there or rent the facility.
And then are or will the inspectors be ICC certified?
Yes and yes. So we have 2 inspectors currently. One has been certified, the other is taking the test probably this month.
Could you just briefly explain what it means to be ICC certified?
Yeah. I mean, the International Code Council is the industry standard in terms of code creation and code adoption in localities across the nation. So while there is the Ohio Building Code or the Iowa Building Code, they're all based upon the International Code Council Building Code or property maintenance code or whatever, fire code, whatever code it might be. They're really the authority when it comes to creation of codes that relate to building construction or building maintenance or even site and in some cases zoning type codes. So through their years of experience, they've also created different training models and certification programs where folks who are administering those codes can become certified in that particular area. And there's a variety of different certifications. And the certifications that our folks would have would be specific to the enforcement of the property maintenance code as it relates to residential properties and also commercial properties for that matter. Does that answer the question?
Yeah, and so does that include then inspecting electrical, HVAC, plumbing, all the mechanicals basically, and some structural components to a property?
It does, and I think what's important to understand is they're looking at, does the system function in a safe manner, and is it performing as it was installed to perform? So they're not disassembling it and looking at the bearings and checking, what condition it's in that regard. They're simply looking to see is the HVAC, is it properly ventilated? Is there any bare wires or any cause for concern in terms of fire hazards or obstructions of the airflow or things of that variety? They're not getting into the system and doing this, involved inspection. They might be looking at electrical outlets to see if they're, if the cover plate's there, it looks and appears to be okay, then it's okay. If it's exposed and there's frayed wires, then that would be a concern. So it's kind of at that level that they would be looking at things. And these are not, these are not hours long inspections. These are come in, make the observations, check the list, everything's good, we're done in, half an hour or 45 minutes or whatever it takes.
And then is there a continuing education component to being ICC certified?
There are, and our folks participate in those as well to maintain that certification.
Okay.
I had a question on the landlords being liable for the utilities if the renter leaves an unpaid bill. Is there another option to go after the rentor, the person who accumulated that, instead of having the landlord take that responsibility?
There may be. One of the things that we're looking at, it's related but somewhat separate from this conversation, is the ability to increase the deposit requirements. So there are some limitations in the Ohio Revised Code in terms of what our utilities office can do so far as the deposits that they require for the different types of accounts, electric or water or refuse or whatever it may be. But we're looking at that because it would make sense to us that you could look at a 12-month history in terms of the utility consumptions at that property and base a deposit on that amount so that you've got a deposit that is realistic in terms of covering whatever outstanding payment obligation might be walked away from by the rentor. So in that regard, if the renter is the one signing up for the utilities and they put down a deposit that is actually sufficient to cover 1 month's utility fees or bills, then we would be in good shape and there theoretically wouldn't be any outstanding left behind monies or unpaid bills.
Okay. Right.
So I don't have that's, like you say, that's something that we would advance separately, but as part of this conversation.
Seems a little more fair to do it that way.
And then that's the idea. No one, it's how do we make sure that we're rectifying the issue of unpaid utilities that are then impacting all of us in terms of, those have to be compensated for somehow. So those are general revenue funds or enterprise fund dollars that could be used for something else that are having to offset that consumption of energy or whatever it was, the water, or whatever it might have been.
Okay.
Chris, when you guys came up with this plan, is this similar, when you came up with the draft, I should say, is this similar to surrounding communities? I know we probably have a worse problem with this than most, but is it similar to any communities around? Is it unique? Is it?
It's not unique. It's what you have in front of you is really modeled after the plethora of examples that exist across the state of Ohio. And we don't have it worse necessarily. We have some of the same issues that a lot of other communities deal with. Some have been a little bit more progressive or quicker to adopt rental registration programs such as this.
That's kind of what I meant, yeah.
But even in our own backyard, I can tell you that across Miami County, all the other communities are very similarly interested in having some provisions comparable to, if not nearly identical to, what we've put forward.
Any other questions from the board? Any other parties want to comment? State your name and address, please.
Eva Silvers, 319 Third. So I got all of the landlords together. This is a way they can communicate. You guys all know I've advocated for a lot of these houses being brought up out of deplorable conditions for years. There's genuine concern there from the tenant side as well as the property owner. A lot of the property owners do not want to be liable for their tenants' bills. They're already liable for the damage. So if you guys could work something with the utility company, I think a lot of the landlords would not be so upset as far as just saying, hey, they might tear our house up and we're going to stiff you with a bill. And that's because you have to understand, if these landlords call the city of Piqua and they say, Jim Joe wants to rent my place, can you tell me if he has been responsibly paying his bills? Can't tell them. Can't tell them. They get told it's private. So if I can't verify through the city of Piqua, why would I be liable to the city of Piqua? A lot of the tenants' concerns too, as well, is if you go into a house, say you've been living there for years, you had no idea there was something wrong. But say, I don't know, there's a tree in the sewage drain, it's backing up, so they're gonna shut the water off. So if you're without water in the city of Piqua, there's a code that condemns that. Where are these people gonna go? It's a valid question, and it's one that you have to look at every angle and every possibility with what's being proposed. And I understand, what Frank and Chris just said, but it's kind of just like it's revised, but it still comes right back to the same answer from what they revised it. So it's not really, it doesn't give much base standing. I am pretty much just going to let the landlords take it from here because, like I told them, I own no home here. I rent here. It's my hometown. I don't want to see it turn into a major metropolitan area. I don't want to see it as dilapidated as it is, but there has to be a common ground. And that's pretty much all I have.
Tony Chappie, 1725 Parker Drive. Reason I'm here is because I think what you're trying to do is great, but you're going at it the totally wrong way. I've been a slumlord for, 20 years. I've had hundreds of tenants. And I guarantee this, one thing I learned was 1 out of 10 people get you. They tear the place up. Nothing I can do about it. I can yell at them, call them bad names, then they kick 3 holes in the door. So I move on and try to keep everybody calm, and I try not to punish the 9 out of 10 people that are good tenants because of the 10% bad people. It all comes down to personal responsibility. I'm not from Piqua. I come from a small town. If you have a couch on your porch, you knock the doors, you say, get that off of there. okay? So I have a few legal questions before we write this ordinance, and I've talked to Aaron and some other people about, I have good ideas how we can clean up Piqua. But they kind of say, well, look on the website, do this, and that. Don't have time for that. But I volunteer for any time you guys want. I'll come give you some ideas. I think we can clean the city up. First off, everybody has the freedom of choice. They can walk in the property, determine whether or not it's nice and safe and clean. If it's not, don't rent it. Don't rent it. That's a choice, right? So with that, do you feel it's all right for 9 out of 10 people to pay a little bit more because that 1% of the people can't make that decision? Because most of us can go in and say, hey, this is a shitty place, I'm not gonna rent it. I'll go down the road. This is not a socialist society, it's capitalism. So we can do that. I mean, and I've talked to the city and said that, but one of the comments I said, why do you think the landlord should be responsible for the bad things that these tenants do in their actions, and they tear it up, the grass grows up? Why, Frank, why do you think I'm responsible for that?
You rent it to them.
Okay, so I rent it to them, I'm providing them a place to live,
So I own my property, all right?
okay,
I keep my property up.
yeah,
I'm responsible for what happens on my property.
okay,
Same as you. You
Yeah.
own property, you keep it up, you're responsible for it.
tenant did it though, the tenant did it.
You made the decision to rent to that tenant, not me.
I'm gonna give us 3 scenarios, and you can answer. You're an attorney, right?
I get stiffed too.
Okay, you're an attorney, right?
Work and
You're
people
you're a
don't
lot
pay
smarter than
me.
me. You're a lot smarter than me, educated. But if you put a hole in the wall, I can make that look perfect. That has nothing to do with it. So, you get someone out of a DUI, you get them out of jail. They go out, they kill somebody the next day, are you liable?
No.
Okay, well, what's the difference between that and my tenant not cutting the grass or not paying their utility bill?
The reality is you're
No,
dealing
well,
with,
shh,
you're dealing with property rights, okay? And as an owner of property, you live in the city of Piqua, you're required to meet a certain standard. If you don't meet that standard, the city, and it is a charter city, has the right to enforce its codes.
okay, but you're making me pay the fine, I didn't do the crime.
And also,
And because I make a profit, I'm liable, same thing. So we'll go on that, okay. On top of that, do we think the city of Piqua can write better laws than the federal government and metropolitan housing and hold people responsible?
yes,
Well, I hope.
Okay, we can write better laws?
yes.
Okay, let's say we write these laws and somehow we cross the line and we violate someone's rights and the city gets sued. Who's gonna pay for that?
The city.
The city will? What about the person who wrote the laws?
The city, certain
Those
things-
are all,
Tony, first of all, the city has a certain amount of immunity, which
Okay.
you don't understand.
they don't
but
have
the
to follow
city-
laws,
No, the city does follow the laws.
but we can make them up.
This isn't a made-up law. This
Well, I'm
has been
talking about-
challenged
listen.
to the Sixth Circuit Court of Appeals, which is the federal circuit for the state of Ohio.
Yeah,
This code actually was modeled off of that community.
yeah.
So it's already been upheld at the federal level, the Sixth Circuit Court of Appeal, which is one step lower than the United States Supreme Court. The idea of property maintenance and police powers for cities to control rental permits and to make laws regarding the condition of properties has been upheld numerous times.
Yeah.
It has. And so if the city is sued, what would happen, just because you want to know, is we would notify our insurance carrier. The insurance carrier will hire attorneys to represent us. We pay insurance for these type of things. And if we were liable, the city could potentially pay. I have reviewed this law. This law has been reviewed by the Troy law director and other law directors in the area. We are confident that it would uphold a statutory challenge.
Okay, but what's that have to do with holding me responsible for what someone else does? like they buy utilities off of Piqua, but I'm responsible? That's like kicking the cat for the dog pissing on the carpet. Am I right?
You own a business, you operate a business.
Okay,
And this is part of operating a business.
okay, you
In
get
the
some
state
off
of
a DUI.
Ohio, I have to pay a fee every 2 years to have a license.
Well, I'm not talking
I
about
don't
the fee,
know.
I'm talking about you holding me responsible.
I'm,
It's just, let me sum it up with this.
I'm not allowed to practice without a license. This is a similar type of thing. You will
Well,
not be able to rent without
I'm
a
talking
license.
about you holding me responsible for what these people do to me.
You have decided to operate a business, right?
That's just like a lawyer,
Just like a truck driver, everybody else. Truck drivers have to have certain
and if they
license.
hit somebody, they go to jail.
If they don't have a license, they're not allowed to operate.
Yeah,
No different. It's a landlord, he wants to operate in the city of Piqua, he has to have a license.
yeah. Well, you're a lawyer, you know legal things. If you want to learn want some good ideas, how to clean up Piqua, I have plenty. But for some reason, the city doesn't, want to listen to me. I've volunteered many times to talk to people, but I can't get a phone call back. It doesn't matter
I
to
mean, if
me.
you want to go to lunch and talk about it with me, I'd be more than happy to.
It doesn't matter to
Tony.
me, but what's happening here is
Hey, sir,
95%
Sir,
of the
your
population.
your time's up.
Okay,
Thank you.
let me at it with this. If you voted for Joe Biden, whose responsibility for the current messed up situation we're in?
Republicans.
No, the people who voted for him.
Thank you. Anybody else want to speak?
My name is Angela Bimmerl, 8655 Fairview Road. I wasn't aware we were going to be able to speak tonight. I had started composing an email to send to the commission and everyone for next week's commission meeting, but I'll just read what I have composed so far, and we'll go from there.
Is it different than what we just heard?
It is.
Okay.
This is concerning the rental registration program. To I, along with my tenants, do not see a need for a new layer of bureaucracy to be added to the Code Compliance Office for the City of Piqua. That office has every tool needed to enforce code violations. If they have chosen in the past not to enforce it, why put this extra burden of rental registration and forced inspections on the landlords and tenants? The proposal the city puts out starts with the legal basis. One paragraph from a legal decision in Centerline, Michigan. While there are also lawsuits and judgments from Ohio and beyond affirming that these rental programs are not lawful or just. The ACLU has taken up a class action lawsuit in the city of Clarksville, Indiana. That's ongoing. Orange City, Iowa has a case going forward. Yuma, Arizona are requiring the administrative search warrant to enter if tenants refuse. In March of 2023, the Commonwealth Court of Pittsburgh, Pennsylvania found the city government does not have the authority to require registration and inspections of rental housing. The United States Court for the Southern District of Ohio, Western Division, Baker versus City of Portsmouth. Tenant or landlord cannot be discriminated against or penalized for the tenant refusing entry without search warrant. I am assuming this includes the fees being charged for warrantless inspections under Piqua Rental Registration Program 150.204H. And that's all I have so far, except that the International Code Compliance Council is a nonprofit organization that members have to pay to become part of, that was put together by architects, construction, and people who want to sell their green energy, pardon my language, who want to sell their green energy along with progressive cities. So, you can say it is the industry standard.
That's wrong, ma'am. That's
and-
wrong.
How is it wrong,
I
sir?
belonged to that organization for many, many years.
It is not a nonprofit?
No, what's wrong it has nothing to do with green energy.
Oh, absolutely it does, and I'll tell
Okay,
you.
it doesn't.
And I'll tell
It
you
was-
another
it was
reason why this
established
rental program.
long before there was a green energy movement at all.
In Gainesville,
It's
Florida.
about code compliance
They have tried they have a
Well,
rental
she's
program.
supposed to tell the truth, too.
I am telling the truth.
No, you're not.
Then tell me who put together the International Code Compliance Council?
It was done so long ago, I have no idea.
Exactly.
And I don't
those are-
care. It's about code compliance.
Go ahead, sir. I will be at the commission meeting next week if you would want to, go
I
back
won't
and
be.
forth. Okay. So, the city of Gainesville, Florida started their rental registration
Do you
program.
have anybody from Ohio or all these other cities in
I
other
just gave
states?
you case law from Ohio, sir.
Well, read it again.
I've already read it. You can go back and review if you would like.
Okay, I won't like.
The city of Gainesville, Florida started a rental registration program years ago, okay? It started out with your sheet of 80 things that they could come in and look at. And along with the city of Piqua, they have the.
Ma'am,
little
can you
disclaimer.
address us,
Sure.
please, with the
it.
microphone?
Along
We-
with the
we
city of
can't hear
Piqua, they
when you
have the
turn
little
around.
disclaimer that not only these items, but in the future, should we want to add something, we are allowed to do that by law. So now, the city of Gainesville, if you want to have a rental, okay, your R value in your attic they're now looking at. They are requiring 1.6 gallon flush toilets. They're requiring low flow shower heads, and on and on and on.
All the
So
current-
where is that going to?
All the current building codes.
Yes, on the current building code, sir.
Right.
So is that where Piqua is headed? So we're going to go in with our list right now of the 80 items, or
At this
however many
time-
they are.
Yeah, I'm
And
sorry.
anything you're allowed to add,
Your time's up.
thank you. I appreciate your time.
Anybody got anything different?
Joseph Harold Gates, 801 Brook Street, Piqua, Ohio. At the 4,400 homes that we have here in Piqua, at 53%, how many homeless people are we looking to have once this goes into effect? Also, on top of that, at 4,400 homes at $65, that's $286,000 for 1 year. Where's that come into all the jobs? There's 10 to 12 jobs there's 10 to 12 people to require to do this job that you guys are talking about. There's absolutely no way. You got 10 or 12 vehicles you have to buy. The city can't afford it. We're already taking money from other funds to finish Lock 9. That's not even done yet. How much longer, how many more people are we going to offend? Not just landlords, but actual homeowners. Your aunt, your uncle, your brother, your sister, your grandma, your mom and dad. If they have somebody living in their home on Social Security because they can't live or afford to live anywhere else, are they subject to be inspected? Are we going to be a community that has no houses but one on each block? This right here, there's a different way to do what these guys are suggesting.
What would that be?
Give a better time limit. 6 months, January 1st is bull crap. Let's talk 5 years. Let's talk 7 years. Let's
For
try
what?
to let some of these people fix some of the things that are on this list before you start smashing and beating everybody. There's not going to be any place for these homeless people to go. Evict them. Evict them. Where are they going to go? There's other towns. People from Dayton, Montgomery County are coming to the city of Piqua. Why? Because our welfare system is better. Because Montgomery County and surrounding counties are cutting their welfare system down. Not Piqua, not Miami County. There's other towns in this county. They're not going to approve this. I can't see how you guys can see that this is a lawful decision. There's got to be some way to compromise with all these landlords, property owners, your mom and dad, your brother and sister. I got an aunt that has my cousin living in her house. She has to claim that she pays rent on Social Security to get a bigger check because she already doesn't get a check. She's going to be subject for this. And you know her, Frank. Is my time up? That's all I got.
No.
My name is Kimberly Miracle. I live at 700 South Wayne Street. I've been buying my property for the last 3.5 years. It hadn't been touched in 20 years. The day I bought it, I went down and talked to Aaron Morrison, said, what kind of permits do I need? Because I want to get started. I've been working on it ever since. Hopefully tomorrow this will finally end and I can just be left alone so I can enjoy my house. I have sunk every penny I've had into it. I'm out of every credit card that I have. I have busted my ass to turn my property around because I wanted to fight for the town that I live in. Yes, I am buying this on land contract, so even though next year you can come into my house at any time. Okay, so now you see my guns on my wall. Oh, are you gonna ask for all my gun permits? Are you gonna ask for registration for everything you see in my house? You know, where does it end with my privacy? What is your true intention on when you come into my house? I work at Shell gas station. I see the homeless every single day, and it just gets worse and worse and worse. 2 weeks before Christmas, you shut down the hotel and make everybody homeless. Yay, what a great city. You took them out of hell and put them into frozen winter with no Christmas.
Wayne Pope from 220 West Green Street. And I agree 100% with trying to fix the town up and fix the stuff. But you got to realize that this $280,000 plus the utility bills, that's all going to go back on the tenants. Because those tenants are going to pay for it. They're going to pay higher deposits because you got to guarantee that you're going to be able to pay their utilities when they leave. They're going to pay the $280,000. Also, we got to do this in an equal manner throughout the city. There's a house a block from my house in the historic district that is falling down, rotting down. I've called the city numerous times, and the answer I get is it's an old man. He can't afford to fix it. The rules got to apply to everybody. The same place with the city stuff that sits around, the city tears down all them houses down there. Next thing you know, the grass is this high. It's got to apply to the city just like everybody else with all the stuff that goes on. It's got to apply to the old man. It's got to apply to everybody out there that's not with this guy and that guy.
Chuck Starrett, 4244 West Deming Road. I have read this thing over, and I think a lot of these people have. It's complicated. It's wrong. It's a black eye for the city. It's an invasion of privacy. The tenants have a right to privacy. They do not have you do not have a right to ask for the land for the lease agreement. That's a private agreement between the tenant and the landlord. You don't have a right to ask who lives there. If they want to know who lives there, they should tell you themselves. That's an invasion of their privacy and their quietness and enjoyment of their house and their home or apartment or whatever it is. I don't have a problem with everything being up to code as far as safety. Everything works, and so on. But if you take this checklist, and I know I talked to Frank and he said, oh, we won't go with everything on this, it's basically the basics. That's not the case.
That's not what I said. I said that Chris would have the checklist. I don't even know what the checklist is like today.
Well, you should know if you put this up.
No, I am in charge of preparing the ordinance. I do not create the checklist. That is something for the planning department. So don't say that I said something that I didn't say. I said that Chris's department would be in charge of the checklist.
But what I'm saying is, this is from the International Maintenance Code. If you read this, and I'm sure you guys have, I doubt if this building will pass, if you really want to get technical. we can't take the housing structures of Piqua and a lot of the rentals are older homes that have been upgraded for rentals, and most of them are in good enough shape that they're safe to live in or whatever. But they won't comply to some of the newer stuff that you want on this list, but the house will be standing there long before your new construction will. Because they're better homes, they're better built, and I had one as a double down on South Main. It was built as a double. The dividing wall was flagstone from the basement to the attic, 14 inches thick. The outside walls were 18 inches, 4 layers of brick, 2 this way and 2 sideways. And that house will be standing on probably the last house in Piqua if it came through. I rewired it, replumbed it, put furnaces in it. It's as safe a house as ever. I sold the house here several years ago. But this is what you have. So now you want to penalize the people that do a good job to try to collect money. And this is basically a money grab. And it basically will be a money grab when it's over with. You'll have 10 more people working in your utility department, or I mean your code enforcement. It's a violation of everything I can think of here on property rights, the right to own. Who wants to buy a rental in Piqua and put up with this? So what happens to your tenants? They're not going to come here because you're going to force them out of their homes because of what it's going to cost them to live there. Now you guys know that you took a job and you take an oath, and the city councilman take an oath to uphold the Constitution of the United States, protect the citizens of the city, to listen to their issues, and the organizational structure of this city, if you've never read it, is the citizens are number 1. The city commission is number 2. The city manager and on down the line. So the citizens have a right to what they say. If the majority of the citizens don't agree with what you're doing, you need to listen to them, or you need to step down, because this is not going to fly in the way it's made up here. It's going to put people out of business. It's going to put nobody wants to invest in this city. And I could go on and on about all the things that's wrong with it, but I want to give somebody else a chance to voice their opinion on this. But this
Sir, I
is
got a
disgrace.
question. If
Yeah.
you're doing a good job of renovating your rentals, why wouldn't you be for this?
Because I think it's an intrusion of me having to put up with a license fee.
If you were the city, how would you ensure that people are doing a good job renovating their rentals so where they're safe for their tenants?
They already do it. You already have it on the books.
How's that?
There's not one tenant, I don't think there's a tenant here or in town that would say they had to sign a lease that said, I have to live here. If that house isn't fit to live in, they made that decision, okay? Now, there's what I would like to live in versus what somebody else might want to live in. It's not necessarily the same standards. But there'll be times when you've had, look how many houses you've tore down. Don't tell me you don't have rules. You've tore down people's houses. You've taken property away. You've done all this stuff, and this is not your issue.
Time.
Time? Okay.
Time.
That's not Congress.
No, that's applied, so that's the code rule.
Hmm?
You guys aren't following the Constitution. It's called the Fourth Amendment. You're gonna bring up Congress.
I didn't bring it up, you did.
You said Congress, I said I did my time.
We don't transfer time, sorry. You're done. Next?
Really? You'll see if I'm done.
Can I make a 2-second comment?
You had your 5 minutes.
Can someone give me 30 seconds of their time?
No, it doesn't work that way.
I just want to say.
My name's Roland Sauerman, 660 South Street. Why, to me, that's discrimination of a tenant. We own houses. Why don't the city say you can go to anybody's house? They just pick certain people that can't afford a house, pick on them, and say what they got to do. Well, since Frank don't pay his house payment, is the bank reliable for what he does? No, Frank is. So why are we reliable what our tenants do? How many of these rentals out here? I bought a house at 13 years. Did the city say anything about it before I bought it? No, but as soon as I bought it, Aaron sent me a letter. Hey, I sent you a letter 5 years ago. about this building, his house. I didn't own it 5 years ago. It was sitting empty for 11 to 13 years. I fixed it up. How many houses in Piqua that we try to fix up to make this town better, and you want to punish us for doing it?
Nobody wants to punish you.
Yes, they do. They want money from us, don't they, every year, whatever?
To make
Why
sure-
don't they go in your house and check your house, make sure it's right?
They can.
I rewired a house because the lights blinked on and off. I rewired the house, and guess what I found out the problem was? The city, outside thing. Why don't they make the city check their wiring once around to some? Maybe that's why these houses are burning down in Piqua. Maybe it's the city's fault they're burning down. These electricians ain't checking to make sure they ain't loose or nothing. When the wind blows out, loosen those wires up. You ever seen anybody check them? No, my house could have caught on fire and killed people. Can I blame on the city and sue them? No. But it's the city's fault. It cost me about $2,000 to wire a freaking house because their connection wasn't right. We try to buy houses and fix them up for people and pick where to live, and you want to tear them down and make them homeless.
You have to, if you're sitting on a seat and you're going to take a position to represent, you want to represent those people.
Tom Homan, 1803 Nicklin Avenue. I just want to talk a little bit about, or I guess I had some questions about how this pertains with the Fourth Amendment. It sounds like a lot of people's concern about this is generally focused around unreasonable search and seizure. Mr. Patrizio, you had kind of laid out, and I apologize if I'm getting this a little bit wrong, but you had laid out kind of a scenario where maybe a tenant didn't want to have an inspector come in, and then the landlord would then give them an ultimatum, and basically we'd be looking at an ultimatum of you can become homeless or you can submit your Fourth Amendment right. Am I kind of correct in that scenario?
The city's gonna have a lot of options with that in that case. If the tenant won't and the landlord's trying, we'll work with the landlord and say, okay, we can do this a couple of ways. We can do an administrative search warrant, which is allowable under the Fourth Amendment, search and seizure.
What would be the probable cause for that warrant?
And that's a good question, because there's a difference between a civil warrant and a criminal warrant. A civil warrant does not have to rise to the same level as a criminal warrant. The civil warrant would be that we are doing code inspections, that we have a right to inspect under our ordinance, that the person refuses, and we would do it having someone at the code enforcement office do an affidavit. They would go in front of a judge. If the judge found that we had probable cause for the warrant, then we would be allowed to have the administrative search warrant. Look, it's probably the last thing we want to do.
I'm sure it is.
Because, it takes a lot of resources to do that. Believe me, we're not going there without a police officer. We're not going to go there and knock on somebody's door and break them down just to do this.
Does this policy have a sunset period?
What's that?
Does this policy have a sunset period?
The policy?
This ordinance that we're passing? Because I understand that maybe you don't want to do that. You don't have the intention of, sending a Gestapo out to go see people and breaking their house.
It's not practical.
This could be something that lasts for 50 years, 100 years.
I can do an administrative search warrant now if I wanted to. We did that with the Red Roof Inn. We did a civil administrative search warrant along with a criminal search warrant. So this law itself doesn't restrict the city from doing that now as it is.
Then why aren't you? Why isn't Aaron?
So that's one of the reasons why. The reason why we're doing this is to get.
I know why I know what the intention is. The intention is good. Again, the question's more for
rental stock in the city of.
Yeah, where's kind of the edges though? It's not necessarily about what will you personally do. It's kind of what can you do? What could a different government or a future set of government officials do?
No warrant can be granted without a judge approving it.
These ICC inspectors, is that correct? So the goal of them going to the house is to look for code violations. And this will be my last question, so I can go sit down while you guys are answering this. What is going to happen if those code inspectors are walking around the house and they suspect a crime? Maybe they see a tenant's guns posted to the walls.
First of all, they're not police officers. Okay.
Yeah.
Obviously, if they walk into a house and there's a bunch of cocaine in there in the middle of the house,
I mean, they're not medical professionals either. How do they know it's not just baking soda?
Report that to the police officer. They actually cannot make an arrest on that. They can go to the police department and say, "Hey, we walked in, we saw cocaine in the middle of the table or crack or
So,
whatever.
so a tenant may need to be concerned that an inspector walking around their house will
They're
make
not gonna
police
open up
reports
drawers, they're not
and
gonna
then
go
give the
in-
police probable cause to
Right.
serve a warrant.
They
as-
cannot go into a house and open up their drawers and things of that nature. It's an open and obvious standard. So if something's laying, like I said, crack cocaine's on the table and they know, I mean, I don't know if the code inspectors even know what it looks like. They could think it's just powder. They could advise the police officers at that time. The police then would actually have to go get another search warrant to do that, and by the time the police were there, it may be gone. Who knows?
And again, I mean, it would certainly be a much safer society if, you know, the police were allowed to just enter your home and look for crack cocaine anytime that they wanted. But we do have the Fourth Amendment that says that that's not allowed. I think what the goal of trying to protect tenants, I think that is admirable. It needs to happen. I know that I've heard some stories about some of the worst of the houses that have been seen around here. And certainly something needs to be done. I think an easier route for this to try to get around what seems to be a real sticking point with the Fourth Amendment here is make it not a mandatory program, but something that can be a resource that can be requested by the tenants. If the tenants believe that they're being wronged by the landlord, then they can then request an inspection. But and maybe not even that. But that would be my attempt at trying to reconcile some of what seems to be glaring Fourth Amendment issues and potential violations. I think as a city government in the United States, I think we owe it to the citizens to not get as close as we possibly can to violating the Constitution, but give it a wide berth so that there is no presumption that we're violating the Constitution. Thank you.
Okay, we need a short bathroom break, so hold on, and, well, one of us does.
Well, I do. Not a problem.
I was warned of that ahead of time, just so you all know, so. Okay, if everybody would please be seated, we're back in session. Thanks for the break. Who would like to speak next? And again, please make it something different.
Jeff Grimes, 1314 Maplewood Drive. I want to thank everybody for coming tonight. There is already a way for the tenants to have any concern about your rental is go to the courthouse, put your rent in escrow, the court checks it out, and then it would be fair. The $65 concerns me because I think it's a money grab. I think it's unfair for the landlords. I think it's unfair for the tenants. And if you have a bunch of rental properties, it's just going to make the rent go up. So maybe we should just let Miami County handle it and save the money for maybe a swimming pool.
Joshua Blackshire, 1301 Spruce Street in Troy. So I'm here tonight actually just because I feel like standing up for what's right. I don't own any properties. I don't even live here. But one of the things I noticed that Frank had mentioned was, that this has been held up in court. But we're talking case law and stuff like that. In 1998, I did a quick Google search and was looking up these rental programs. And in 1998, actually it was the Ohio Attorney General at the time had issued a statement that said that this is a violation of the Fourth Amendment. And they cited off a bunch of case law. This is on the Ohio Attorney General website still, so you can look it up yourself. And in 2015, the city, I believe it was the city of Portsmouth, was ordered to refund all of the money that they had collected in their rental registration program, which sounds very similar to what's being proposed here. They, same thing, found that I don't even know if it was the inspections inside, but it was the whole licensing program in general they found was a violation, and they ordered the city to return all of that money back. So that's almost $300,000 a year that for however many years this goes until it's found unconstitutional, because I think there's enough people here. They're going to fight it. They're going to get lawyers. They're going to do something. And that's a lot of money that's just going to have to be paid out by the city of Piqua. And I think it's a dumb idea. And as Jeff just mentioned back here, there's already remedies for the tenants. If they'd feel like their house is unsafe, they can go and escrow the money. So I get it, like the program is supposed to protect the tenants, but the tenants do have protections. We need to educate them more on it. I do believe that we need to clean these properties up, and I'm not opposed to doing something about it. I just feel like it's the wrong way. So tonight, I get you guys are not actually voting on the issue, but you're voting on a recommendation, which the city commission holds very, very high up. So I'm just recommending that you say no. Thank you.
Anyone else?
I just have more of a comment. My name is Candy Hale. I live at 820 Boone Street. We bought a property a couple years ago at 221 West Green Street. Saw so much potential in it. What a beautiful building. It needed tons of work. We put in $40,000. We got messed with constantly. We sold it. Now the people we sold it to hasn't done nothing to it in almost 2 years. Why is that? Because they're a $2 million company. They're also the people that bought Z's. They're also the people that has bought the other buildings across the street from Unclaimed Freight. Why isn't their responsibility as much as mine was?
Are they renting?
No, it's just sitting there empty. That building is so beautiful. We wanted to keep it. We offered people $15 an hour cash. We couldn't get nobody to come in and help us. My husband and I were there almost every day. And now here it is still sitting there and nothing's been done to it.
So you say you were messed with. What does that mean?
Aaron Morris would come down there. Oh, we need this done. We need the deck done. We put new roofs on. We put new deck. We cleaned the deck. We did 42 windows. We done so much stuff to that building that the previous owners didn't do anything to. So after a year and a half, after we was messed with, and he said, oh, we ain't even started with the inside yet, we just put our hands up and said, okay, let it go. And that's a shame because we have worked hard. We've owned our own house for 23 years. We grew up with nothing. Did all that ourselves. Where's the potential for everybody else to do the same thing? Why? Because they're $1 million people? Should be fair for everybody. Thank you.
Anyone else?
My name is Cleta Lovell, 824 and a half Nicklin Avenue. And the question is, do you really want to upset 4,000 people with what you're planning to do?
Can I ask you a question? If we're improving the conditions of some apartments for living for our citizens, you don't think that's a good idea?
Well, it is, but a lot of time the tenant is at question as to why the things are the way they are, and they don't inform their landlord. So it would be their place to inform their landlord that they needed help, wouldn't it? I mean, and you're just gonna
This would take care of that.
upset? Okay.
Yeah, at the end of the day, if we can improve the conditions for some of these apartments, you don't think it's a good idea?
Okay, yes, it is.
Okay,
So.
that's what
that
we're
was my
trying to
question.
figure out.
Okay, because my landlord is very understanding and he gives you a chance after chance after chance. And it's usually the tenant that ruins his chance. And with them having to pay, the tenant or the landlord having to pay the utilities, I don't think that that's fair either, because your tenant should be responsible enough to take care of that.
I think that that's something that needs to be worked out still. In any kind of agreement, it needs to be worked out of how the Piqua Utilities gets that money that's owed.
The salesman sells a car, the car gets repaid. They don't go and garnish the salesman's wages.
You want them to repo the house?
The salesman that sold the.
If you want to come up after she's done, you can go, you can do that.
Sorry, had his time.
Huh?
Thank you.
He's had
Been
his
up here already.
time.
We don't need any repeats.
Brandon Vercolito, 1111 Marwood. Point of clarity, are we going to be responsible for utility bills? Yes or no?
I think, based on what Chris told me beforehand, what it looks like is that if there's an outstanding bill on the property, that the utilities will not be permitted to be reinstated. So, in the
So
case
yes.
of, so if you have someone that stiffs you and you have someone else that comes along, I mean, you're personally not guaranteeing, but they're not gonna hook up the next tenants.
So we are.
Yeah.
Okay, let's just call it what it is. You're gonna have us guarantee other people's bills.
Yeah.
Do landlords typically ask for a deposit, don't they?
Yeah, by law, I can only charge a deposit of what my rent is. Otherwise, I have to start giving them interest payments.
Right.
So there's nothing in the law that protects me against utility fees. And if you guys can't manage your business, which is the utility company, then you should sell it. Troy sold their power company.
Part of management of a business is getting the money you owed.
Right.
Right.
That's our business, is to get the money we're owed, not the money you're owed.
Their business is getting the money they're owed, and they're trying to figure out how best to do that. From
That's the
landlord-
people you guys do business with.
From the landlord or from the tenant?
You're not turning them on for me, I'm not living there.
You own it.
That doesn't matter. Does that work for all of Mike Sherry's commercial properties? Are you gonna require that? Someone runs up a $40,000 electric bill, goes bankrupt, they come after him, is that what's gonna happen? Or is this just residential?
I don't know.
So I agree with you. I did buy that building, hold on a minute. I did buy the building at 221 Green Street, and we do have a capital plan to address that.
Has nothing to do with rental registration.
Well, she wanted to know, so I just wanted to
And
address
I
it.
understand that, but you should probably have that conversation after the meeting.
I'll talk about whatever I want to talk about with my time, thanks.
But you'll address us,
I
not
am.
the people behind you.
That's fine. What I'm saying is you're not applying the program fairly. We all know that. I know that. You know that. Everyone knows that.
Well,
You guys can deal with that.
What should it be?
No, I'm just saying, we already know you don't apply it fairly. Like,
What
everyone
should it
just-
be? Instead of just saying everything that's wrong, what should it be?
I like adult-to-adult communication. Hey, you got a problem. Okay, thanks. Here's what I propose to do
So when
with
your
it.
tenant runs out and owes a month utilities, what should happen?
You guys should go collect it on it.
Okay, hey, I'm asking him, guys, not
You
you
should go
all.
collect on it.
We don't
Just
need to-
like I sell my collections to my property management software and I get 50% if they get collected on. Sell it to a collections company. Simple solution. My other point is you cannot regulate poverty. What we're trying to accomplish here is to regulate poverty, right? The bottom 5-10% of the community that has felonies, what other mark against them, and the landlords that choose to do business with them, they provide a service. Is it a service any of us really want to wash our hands of? Probably. Like, I don't deal in that part of the market, but that is a service that is provided in the market. Those units are, yes, slums. However, because the poor are immobile and because felons can't do anything in our society, when we then take their housing away, what happens? Where do they go?
Here's the problem.
Where do they go?
Here's the problem.
They go to the street. And like the murder that happened recently of 2 Piqua people from a house on Roosevelt, which I'm pretty sure was condemned, they will continue to cause problems in our community. If you look to any major metropolitan that has these programs, they have a homeless problem. Yes, I will make more money. My property values will increase. My rents will increase. Supply and demand will work. But you'll still have a portion of our population that is immobile and therefore homeless in our society. And you guys aren't ready to deal with that.
There are homeless shelters in the county.
Do the math. 20,000 people in this town, less than 5% of that rental is probably about, what, 250 dwelling units that are really bad, right? You've done the math. 250 times, say, 2 or 3 adults. Let's forget about the kids. Hopefully, the state will take care of them. 2 or 3 adults. What are we going to do with 500 to 750 homeless people additional? Can they handle that?
The county?
All of them?
Up to them.
No, it's not. It's up to us. They're going to stay here. Where are they going to go, Brad?
They can't go on the street, so
Where are they going to go?
they have to go to the homeless shelter.
How are they not going to go in the street? There's a homeless encampment right over here.
Sorry, you're done.
You don't make any sense, Brad.
Next. Anything different? We have a time limit, ma'am.
Sally Hensley, 505 Water. I'm a tenant. I think what you guys are trying to do as in enforcing code is fine, whatever, but I don't think it's your guys' right to enter my home where my child lays her head at night. Why is it any of your guys' business? I have a landlord. I rent from him privately. He should be the one to be able to come into my home at his notice of 24, 48 hours.
That
Why-
would still be respected,
Okay.
ma'am, because we're working through him to access your home.
Okay, it's my time. Please let me speak.
Tell the truth, then.
I am telling the truth. It's my landlord's property. I'm renting from him. I'm not renting from Piqua. That's all I've got to say.
Thank you. Anyone else?
Steve Yanni, 1804 Echo Lake Drive. Frank claims that this ordinance has been reviewed several times. In the very first draft that's still posted online on the original registration webpage, very first word in big bold print, registration. So all these attorneys looked at that and didn't catch that. Also, okay? But all these attorneys looked at that. And the packet that was downloaded last night is not even the most current version of the resolution or the ordinance. They revised it again yesterday, and that didn't make it to your packet. So I don't know what the current ordinance looks like. Okay? No, I just walked over there. Anyway, if you go down Wayne Street, and the second house on the west side, or second building on the west side, before you get to the corner of Wayne and Wood, look at that building. The city of Piqua actually bought that in April of 2022. And they bought it for the same price that the guy who owned it bought it in 2006. Look at that building. Talk about homeless people. Irvin Bald, turn the corner and there's an alley and you can drive in the back. So go down Wayne and then turn on Wood and take the first right. Look at the back of that building. It's in horrible shape. And yet Irvin Baldus owns the building that sits on the west side of that alley. And they were all over him about his property for 2 years, threatening to take him in court, all the selective code maintenance. And look at that building. Homeless people were kicked out of there. I'm sure Marcos has probably been down there, or somebody from the police department. And it's still that way. Now the city turned around and sold it to somebody else, and it's still a train wreck. So how are they going to enforce when they can't even take care of the stuff that they're doing now? They can't even write an ordinance that doesn't have mistakes. The presentation that they made had the word recommended spelled 11 times in every slide wrong. And I expect these people to be able to do anything competently? Go ahead. I mean, I could go on and on and on. I sent an email today, and it was supposed to be submitted for 12 o'clock, and you people did not have the email, and you should have had it. It says on the website, if there's an email submitted for 12 o'clock, that should have been my representation. I walked up there, none of you had it. Why not? Nothing in this town runs the way it should. That's the problem. You got plenty of laws. You got plenty of them, but selective code enforcement, that's all it is. Now, I have 2 rentals that are sitting empty. I had COVID in March 2020, and it destroyed my entire nervous system. I had a brain lesion group from 2 millimeters and 13 millimeters in 23 days, 9 MRIs. I've been to Cleveland Clinic. I don't have the wherewithal. I'm just now maybe back to 30% of the person I was. You expect me to do what? I've got a brother who's half owner and he lives someplace else. So if I rent it out and I violate, don't comply, are you going to throw my brother in jail? Because the penalty says 30 days in jail. That's part of it. Take out the jail part. Just fines, okay? This is a civil matter. You're not throwing anybody in jail. Correct the daggone thing. Nobody should go to jail because they own a property. That's nonsense. Irvin Baldus went to jail in 2008 because he owned a property. And he did. They gave him probation, and he didn't comply. But he didn't know he was going to jail. He didn't understand the judge's order or anything else. He's too stupid. Well, I mean, he's not a stupid guy, but he's too stupid in that manner to understand what's going on. And this is what you're going to do. You're just going to ruin everything. I don't mean you personally, but this is a train wreck. Chris lives 2 doors down from me. And I didn't know about this until 5/21. 5/21. I didn't know. They had a workshop, a presentation. I didn't know anything about it. I don't have anything else to say. Thank you.
My name is Mike Sloan at 9525 Mexdoth Drive in Piqua. Something that kind of struck me as a property owner. We talk about the utility problem, and I realize that the city is trying to address that property. And I would ask you that when you do that, think about who's supplying the services. City's supplying the services, which you've already acknowledged, but the landlords are providing services too. When those people run out on you, you've got a minimum of 2 months' rent. If you try and get them, that's a lot bigger normally than utility bills. And I think that the landlords take that burden on. Yes, we get a deposit. Generally, those deposits go towards problems within the unit. For anyone that owns property, they know that that's true. Renters don't treat those rentals like they would their own property. That's just the way life is. But I think that when you're making the recommendation of the council, take that in mind, that the landlords are being taken at the same time the city's being taken. And I think we're being taken for a lot more. Money-wise, we are.
Okay, so I don't see anybody else stepping forward.
Just a quick question. I'm not quite sure yet on the utility. Phil Sullenberger, I'm sorry. Broadway Avenue, Piqua, Broadway Street. Okay, we talked about the utilities, a couple different things. I understand. I'm not going back on it, but I guess the biggest thing is the stormwater deal. When you sell a property, you have to pay up stormwater. Now, if this does go through we said it two different ways on landlord. Ultimately, landlords are responsible for the utilities, okay? No matter how you address it, but it's the way it ended up being. So, that could not go back to whenever. It'd have to start effective when it passes, before we'd be responsible. It wouldn't go back like if we owned a property for 20 years.
There's some utilities that you may already be responsible.
Stormwater.
Right.
Was the only one that ever was addressed.
So, I'm not sure about wastewater. I have to look at that.
Excuse me?
I'm not sure about wastewater. I'd have to look at that one. But water and electric, you're right.
Stormwater is the only one that's ever been charged on a sale of property. I just want to make sure that if you go with this.
Go forward. We aren't gonna, if I'm right, RJ, you probably might have it. I would think we would only go forward on the utilities from the time of the ordinance.
Yeah, I'll certainly leave this up to this body.
But I just wouldn't see if you had.
I'm assuming, Phil, I'm not 100% sure. I'm assuming that would be a decision that the administration would have to make. And I'm assuming, and maybe I'm assuming wrong, that it would be after the ordinance is passed.
Because, if it goes prior to, you could talk, a landlord should be $100,000 or more in utility bills collectible.
I don't know how far the records you can go back. So I guess my answer to that is I really don't know.
Yeah, that's a huge concern. That would be my.
That's a question more for the administration to answer than myself.
That really needs to get, I think, addressed before people get, because that would be something for a legal situation, yeah. Okay, I appreciate you. That's a big concern of mine, besides a few other things, but that's the biggest concern right there. That could get extremely pricey. Thank you.
Thank you.
Hi, Tanty Strumminger, State Route 36. I just have a question on the utilities. How long do they let utilities go not being paid by a person? Does anybody know? Do you know, is it a month, 2 months, 3 months?
I would say as soon as that bill's in the rears, they shut it off.
Do they?
If there's especially if there's nobody in there.
Okay. What I'm asking for is, you're putting this in place and I'm not trying to be negative of our tenants anywhere. But if people start knowing that if they're not paying it, it goes back on the homeowner, what is their incentive to pay it? You know what I'm saying? What is their incentive to pay that bill? If
The
they
bill-
know I'm going to have to pay it if they pick up and leave.
Oh. I don't know if they're thinking that far, but
Well, I'm thinking that far.
they're already running out on their bill.
And also, you know, if you're coming in and expecting houses, like we're working on one that we purchased now, and you call up and say, hey, I'm coming, or it's your turn to be inspected. Do I have the right to deny you to come into my house at that time because I am working on it?
Yes, well, you won't get your permit.
But nobody's in it yet, so.
No, that's
it's-
not
it
an
doesn't
issue.
matter. When it's
If
done,
you're
I can
working
get it
on it,
permitted, but what I'm
certainly.
saying, do I have at that time to say, no, you're not, because I'm in the middle of
If you tell
redoing
us-
it? If you walk in right now, I'm gonna get fined.
Yeah, if you're not
know
done,
what
it's
I'm saying?
crazy.
You,
Our
why
intent-
would they condemn it? I'm sorry, I'm sorry.
Our
But my question is, you know, do we have that right to do that so that I'm not paying again and again and again and paying fines?
Well, you're not gonna pay reinspection fees. The fee that you pay is a yearly fee.
Okay.
So if you're not renting, which is an option, you can say, okay, I'm not renting.
If I'm remodeling it, I'm not renting.
Right. At that point, you wouldn't have to have the permit, but once you start renting it to an individual, you would have to pay that permit fee.
Okay. I'm just asking, because I haven't
Doesn't
had a
mean
chance
that
to read it all, because
Right.
I just found out in the last week or so that this is even going on, and I have not had a chance to read it all, but it's just been things sitting there bugging me, so I thought I'd better ask. So thank you
Good.
for your time.
Thank you.
I have a question going on what she said. First of all, in the paper that I have was revised June 2nd. I don't know if there's another one after that.
I have the 12th.
12th is the latest.
Okay, well, that's not on the website. I couldn't find that one. Anyway, but it says the application fee is $75, not $65, as Chris stated. And the other thing is Frank just said that there wasn't an additional fee, and according to this revision that I have, is every time they go in, it's a $75 fee. So if you don't have outlet covers on, and they have to come back to check that you have outlet covers, you're paying another $75. Is that correct?
That's not my understanding.
No. So the updates that were made were June 12th, yesterday, and it was in response to some of the comments we'd received and making sure that the spelling and things of that nature were all also corrected. So the fee structure that we discussed at the work session was 65. There was confusion in the individuals who drafted it and their thought process that they put 75. It's 65. That's what's been presented to the Planning Commission this evening, that adjustment plus the other two I noted. The one being that we didn't put any language in there about the owner having to be, guarantee utility payments.
Right,
And then
and the
the landlord, right?
Right. So
So-
then, say they have to come back and they have to do 5 inspections before they are approved. Then they don't have, they're paying the $75 one time.
65.
65, right.
Okay,
Yep.
just want to make sure. Where do I get a copy of the latest?
But all this will be posted to the website and or I can send it to you, but either way,
Okay, because I'd like to have a copy.
Of course.
Since I've gone through to find updates.
of
So,
course.
Thank you, Chris.
And
I appreciate it.
that's part of the public comment input process is, there's been a lot of good comments this evening, a lot of good information. I've been taking copious notes. So, if there's opportunities to improve what's been drafted, that's what we'll do. So, but I'll get you a copy of where it is currently.
Thank you.
Thank you.
No.
If you let him, you have to let everybody.
So why was it completely renumbered from 150 to 109? And why, every time you made a revision, wasn't it uploaded to the original website, each revision? Why is the original April revision the only one on the website?
Well, as I stated at the beginning, our city planner's out ill. So that, unfortunately, that may have something to do.
No, it was revised on 5/30, that didn't get uploaded. It was revised on 4/2, that didn't get uploaded. And the most recent version that made it into your packet was 4/2, because I just downloaded it last night. Then I walked over there today and found out Crystal said, well, it was revised again yesterday. I mean, if you're going to speak on something, you have to have the most current version to look at. So she was just up here, and the version that was revised yesterday changed things from the June 2nd version. It's crazy. I mean, you know, you can't. That's why I sent you an email today saying, you know, hey, the thing's been completely redone, and there were supposed to be public comments. Commissioner Lee and Commissioner Grissom at the end of the workshop asked that the public comments be posted online. Where are they? Where are the public comments? They're not online. So this shouldn't be even occurring tonight, in my opinion. This is premature. It should have been tabled or removed, as I stated in the subject line of the email I sent.
Again, we didn't see that, so.
Well, thank you. All you saw it when I walked up before the meeting.
Anyone else? Okay, if it's new. I'll give you 2.5 this time.
Okay, my point is, we're trying to fix a problem, and we're identifying people and trying to punish the landlords.
Nobody's trying to punish anybody.
Okay, but we're.
That's a bad word.
That's what we're doing. Us landlords, we spend thousands of dollars and hours fixing our places up. The problem is 50% of the people are landlords, but we're not all the problems. There's just many property owners that have the problems. Our problem is the people we rent to sometimes tear it up. So instead of attacking us, work with us. We have good ideas. We can attack the problem, not the people, and solve it. That's simple.
Again, I would suggest you meet with the
talk to
city and give those ideas to them.
I have. I've been fined $400 because someone didn't cut the grass.
Now,
I'm not these people parent. You
I'm talking
guys
about
say-
the way you want to clean up the city.
Here's how I want to
Let
clean up the
people
city.
know that.
Here's how we clean up the city. The bottom line is this. You address the problem, okay? I'm not these people's parent. If I go and belittle someone, say, clean that up, do this, I can't do nothing. I'm powerless. We have laws and regulations that regulate what we can do. We can't just go in and say, hey, get a little bit of common sense, clean that shit up. We can't do nothing. And if we piss them off, they punch holes in the wall. So we have to be a little calm and just say, hey, man, could you please pick that up? Now, I've talked to Aaron, and poor Aaron, he gets yelled at all the time because he's trying to force all this stuff, and he has to be the bearer of responsibility. But when this person tears stuff up, he comes and yells at me, then I'll yell at him, but the problem's here. It's that simple. I mean, it's that simple. Laws don't matter in this. This is a common sense, common cleanliness problem. We can pass all the laws we want, but we can't control people. Bottom line. If you can't control people, tell me how. That's all I have to say. And anybody here knows how to get a hold of me. I'm not hard to find. I don't have a job anymore, so hey, give me a call. We'll do lunch.
Thank you.
I have been buying my property on land contract. I have been a renter for many years. I know most of you are homeowners and landlords. If you have a problem, it's plain and simple. You take your rent to the courthouse and pay it. If I have a problem with a rent, I'm the renter, I have a problem with the landlord, I go to the landlord, it's not addressed, I take my money to the courthouse. That's what you're told. If you're not taking it to the courthouse, it's the renter's fault. It's not the landlord's fault. It's not your job to come into my house. If I have a problem and it's not being addressed, I'm supposed to take that money to the courthouse. Everybody should know that as a renter.
See, now we're cycling all the way back through.
Yeah.
I got everybody together because I thought we could come to a common ground. I did not want to see the city blow up in chaos. That was not my intent. My intent was to come to a resolve that was best and worked for homeowners and renters. I do want to point out a couple of avenues of anger. There has been code enforcement for 30 years. Somewhere, somehow in this city, there's been code compliance. There have been people receiving paychecks for doing that job, And obviously, the job was not done adequately enough, or we would not have 115 homes without kitchens, 33, 37 with no plumbing. But I'm gonna be honest, a lot of people's anger comes from that. You know, everybody's talking about finances. There's a lot of money gone in the last 30 years that just rolled out in a paycheck to a city employee that did not do their job. And we're seeing a lot of backlash from that because a lot of these houses didn't get this way in 5 years, 10 years. And we've had code enforcement. So at some point, the city has to take accountability for that. But also, we're never going to get to a common ground if we are not able to have an open forum and an open dialogue. And I get it, people are heated, people are mad. But respect will get everyone a lot further than a cast out of overtone of authority. And that's all I have to say.
Hi, this is my first time up here. So, Tyler Fonzie, 1803 Nicklin. So I'm neither a landlord nor a tenant. I just go to these things because I think they're kind of fun and it's interesting. So this actually makes me think of the Nicklin Wilder Commission back in November 8th. Same amount of turnout, and it was concerned citizens that came out to speak about something they were concerned about. If they weren't concerned about it or they didn't care, they wouldn't show up. They're similar to how we were at the Nicklin Wilder event. They were coming with specific comments, concerns, and questions that are relevant and valid. Whether anyone likes each other or not, whatever the case is, they care about the city in their own manner, and they want a specific change that helps them and the tenants. And they don't like this specific change. That's the whole point. They're here. With the Wilder situation, I would like to implore the voting members to consider the way you guys considered us when we spoke in November, our specific concerns, and reflect on your voting based off of that. You guys could specifically vote and work with these members and then come up with a new idea that works better. These people are intelligent. They are coming up with great questions and great concerns. I'm sure they would love to work with you all, anyone in the city. And I doubt that they, don't want to do that. So that's pretty much it. I just hope you guys can come up with something nice and work with the citizens.
Thank you.
Mike Haynes, Looney Road. I'm a landlord here in Piqua. I've got 10 tenants. I don't put a lot of money into my properties. I don't consider myself a slumlord, but I consider myself someone that fixes up the inside by putting new carpet, new paint, and I fix the insides up really nice. But I keep my rent at $475. It's my first tenant's rent. And she's been at that $475 for a 3-bedroom attached garage for 13 years. My property taxes have more than doubled on that property. Have I raised her rent? No. Am I gonna have to if you guys come in and start saying, hey, you gotta do this and you gotta do that? Probably. I'm probably not gonna have a choice. If it was just one property, I wouldn't have a problem with it. But if you're gonna go to all my properties and say you've got to repaint, you've got to put up new gutters, because I've dealt with this with Aaron, and he's been very reasonable. I've painted and put up the new gutters and everything that he's asked me to do, and the problem I have is if I have to do all these at once, that tenant that's paying that $475, she's not going to be able to afford the rent that I'm going to have to charge her. I'm not going to be able to afford to put new gutters and new siding on some of these houses because I can't do it all at once. I don't have that kind of money. You know what I mean? I'm worried. I've worked very hard to accumulate these properties. I bought them all cash. I don't have mortgages on them. Recently, before you even started this, I put a mortgage on one of my houses, the house I have in Huber Heights. I put a mortgage on that house. And the reason I did it, so I could start doing what you're wanting me to do. I've taken my house on Woodster, on Madison, which they've actually put it in the Piqua Home Improvement. They've featured my house on that. And that place has been empty for a year and a half. It cost me $5,000 to put gutters on it. $5,000 to have it painted. I could go on. I put a new furnace in it. I put new windows in it. I just got done putting new granite countertops and new cabinets in that place. So I'm on my way. I'm going to try. But if you guys come and you take all my properties at once and you say, you have to meet these code enforcements on all your properties and you have a limited amount of time, I'm not going to be able to do that. I'm going to have to sell my properties. I'm going to have to either raise that single woman's rent from $475 up to $1,200. There's a way of doing this, but this is not the way to do it. I look around when Aaron comes to me and says, hey, you need to paint this house. And I stand on the front porch of that house and I look at all the other houses around me and I think to myself, why am I being picked on? Why do I have to paint my house when that garage looks worse than my house? And that house over there, and there's what it looks like. I agree with what you're doing.
And those are property owners you're talking about.
That's my other concern here, is that why am I being picked on as a landlord, and the people that actually own their homes and they're not renting, why aren't they being picked on? Why aren't you going after them as well? There's a way of doing this, but this is not the way to do it. This is not the way to do it. You're going to put me out of business. I have a 4-year-old and a 4-month-old at home. I'm 56 years old. I work at KTH full time, and I'm putting mortgages on my house to try to do what you're wanting me to do without me even asking. And if you go through with this, I'm going to have to start selling my properties. Stuff that my 4-year-old, my 4-month-old should be inheriting is going to be sold. Why? Because you're going to make me pay utilities on a tenant that's not paying their utilities. Recently, I had a tenant that took a meter from somewhere else in the city, and he put that meter in because you guys disconnected his electric, okay? And they disconnected his electric, and to be able to do that, they had to disconnect the tenant downstairs because the power comes down, comes into one meter and the other, okay? You guys made me put a new meter box in and put a new drop in so they don't have to disconnect that tenant downstairs to do that again. I can understand that to a certain extent, but I also think to myself, I'm not in the electric business. I'm not supplying. Why am I putting a new meter box on the side of this house? When the gas company came in and took the meters out of all my basements, Vectren put those meters outside and didn't charge me anything. Right now, I'm being charged for water for that exact same house I'm talking about because the meters are in the basement and they can't get into the basement to disconnect it. So now you guys are wanting me to pay to have those meters put outside. There again, I'm not in the water business. Why am I being charged for that? I'm sure you all can understand where I'm coming from here. There's a way of doing this, but this is not the way to do it.
Thank you. Okay, it's 8:05. Is there somebody dying to say something new, or is it pretty much everything been hit? You are not.
I've been a landlord for 40 years, and I've dealt with some shit. I could retire on the rent I've lost and live comfortable. So people that don't own rental properties don't even begin to know what it's like. You could try to get the best tenant in the world. 2 months later, they got porch furniture, broken windows. See, you guys don't realize the money. I put $35,000 into four units in the past year. Pennies on the dollar I get back from the tax man. And you guys want to come down on people and make them pay for this? I understand to beautify things, but you guys are beautifying things on our dollar. You guys seem to forget that too. You know, who's paying for this? We all are. We all are. As far as you're not a landlord. You don't even begin to know what's going on because you ain't never been there. So you guys need to take some understanding in everything we do. I used to work a full-time job. I took care of my father for 15 and a half years, raised my boy, and took care of 9 doubles and 4 houses. And I'm still doing it. I've got rheumatoid arthritis. I just had cancer in my nose. It's gone. Am I going to give up? But I don't want you guys coming in telling me what I got to do. I put my money right back into my properties, and that's something you'll never know. What about land? What about homeowners? What about homeowners? You seem to be addressing the landlords, just the landlords. Write it on paper, right on your site. It's the landlords. Everybody's going to say it's the landlord's fault. If you own a property and there's work that needs done over there, you're going to bypass them. You're attacking us. You're attacking us. You better choose your way of attacking and not make an attack, because this will backfire on you.
Okay, I got a couple questions for Chris. It seems like if I could sum up all these comments, I would say there's concern about privacy from the renter. There's concern about paying utilities from the landlord. And I think it's unclear as to exactly what kinds of things would be required of them to address. In other words, what kinds of code violations would they be responsible for in their properties?
History of selective code enforcement.
What's that?
There's a history of selective code enforcement that's very detailed. Selective code enforcement.
Well, I can't speak to history, but I can say that you know, I think that this draft, if we addressed a timely situation where a tenant could be monitored, could be, you know, inspected. Say they're on vacation for a week, so say it's a 2-week situation where, okay, the landlord has to notify them that somebody's going to come in from the city and inspect that yearly inspection. And they've got 2 weeks to make that happen. I'll come up with a date, come up with a time, and so forth. I personally think that would be probably a good solution to, you know, work that out with the tenant. I do think there's probably a way out there for Piqua Utilities to collect what they're owed without necessarily relying on the landlord. I say that, Frank, I don't know. Chris, I don't know. It seems like, though, there ought to be something that can be done, and I'm not asking you guys to make an answer. I'm just saying that that's an issue. And what was my third?
What? Can I talk to that a little bit?
Yeah.
Is there a way that we can require the deposit to be collected by the city for the utilities instead of the landlord?
Well, they do.
I mean, to cover the
Month ahead.
month ahead. I mean, to cover the month ahead, and then the landlords wouldn't have to be involved with that. Is that an option?
That was what I commented on at the beginning in terms of the amendments to the proposal. So rather than asking the owner to provide a guarantee, we're looking at, is there a way we can increase our deposit requirements and still remain compliant with the with the
We have to do
revised
it
code.
on an estimated basis of what that apartment uses currently.
Because you use the shit ton of electric and water doesn't mean I'm going to when I move in.
Well, either
So-
way.
So the idea is what you're asking.
Yeah.
And that's what we need to look at closer. I don't have the answer, but that is,
Right.
based upon the comments we received, we understood that that's a concern, right?
Yeah, that's
So
a
how
big
can we-
concern, so-
How can we address that and remedy the issue that we have with unpaid
Right.
utilities, right?
And that would,
And
that
that-
would take a
that's-
lot of concerns on that part of it.
And to me, it seems like the whole privacy issue can be solved with just a timely situation.
What I think what you've described is how it would be administered. So you have to have a coordinated effort. There has to be a communication to the property owner that your property it's time for an inspection. And granted, these are once every 3 years, if that frequent.
Every 3 years?
Once every 3 years. Now, if there's no findings, and there are other properties with greater needs for the inspector's attention, it could be more than 3 years before they get back to that one. So the communication with the property owner to let them know that it's time for an inspection, and then there would be a coordination of scheduling. It's not going to happen the next day. The property owner is going to need some time to be able to contact his tenant. They're going to need some time to be able to find a day that works for all parties.
Right.
And then it would be calendared, and then the inspection would occur. So
No, I
the-
think
the-
that there's something there can be worked.
Yeah.
The
It's not.
other thing is, I think there ought to be a list included in the draft, like a checkpoint of what your inspectors are looking for. They're not looking for granite countertops. They're not looking for new carpet. They're looking for basic systems only.
So I want to speak to that.
Okay.
So, to me, this program is to ensure that a tenant can go to their faucet, turn on the water, get water, it drains properly to the sanitary sewer, it doesn't run all over their floor, it
Toilet
doesn't
flushes.
drain to the, it doesn't drain. Can I finish? I've listened
hey.
for 2 hours. That it can drain properly to the sanitary sewer, not all over somebody's floor or their basement. That they can go to that same faucet, turn it on without fear of being electrocuted because the electricity was not grounded properly. It is also to ensure that the hot water heater is vented properly and has a working pressure relief valve so it is not sitting there like a missile ready to launch. It's about making sure that the HVAC is working properly and is vented properly, so there's never another grandmother who has to bury her 2 grandkids because they were overcome by carbon monoxide fumes. It's to ensure that a tenant can walk across their floor without falling in the basement because the termites ate completely through the floor joist, and the fix was to scab it together with a 4-foot-long 2x4. Is to make sure that the roof trusses aren't sagging and ready to collapse under the 5 layers of asphalt shingles. Every one of those things is something that I personally witnessed and saw in my 11 years as an inspector. So to me, this program, however it's worked out, and I do think that there are things that can be worked out, it is about meeting minimum building standards. It is about life safety issues, and it is about the right for people to have a safe place to live.
In those cases, did they pay their rent to the courthouse?
No, they did not. They called the city and said, I need help.
Then they should have came in.
Hey.
They was invited in. I need help.
So you were an inspector for the city, sir?
I'm sorry?
Inspector for what jurisdiction?
City of Troy.
City of Troy, okay.
Are you gonna inspect every house?
Right now, this is just addressing rental properties. It could be there's probably another ordinance coming. Okay, that's enough. If we're gonna,
Yes, you can. It's just a quick question.
let's keep order. Come on. Okay, so any other questions or comments from the board? Okay, I'll open it for a motion.
I'd like to make a motion to recommend PC 21-23 to the City Commission based on the following. To ensure rental properties meet minimum building standards and that this program is designed to mitigate life safety issues.
I would also like it to be amended with the items that the 3 items that I spoke about.
Would that include looking into the deposit with the city instead of with the landlords?
With whoever to get it off the landlord.
Right, right. So some way to take that out of the picture.
So we're talking life safety
So
issues.
if you're looking to make a recommendation, just say make the recommendation with the recommendation that the landlord payment of utility not be recommended is what you would do, and just go forward with the recommendation that way, with removing that provision.
Removing the provision of the,
The landlord paying the utilities is what I'm hearing from you. Is
oh,
that-
well, I was not suggesting that it just go away. I was
Okay.
suggesting that somehow it be,
It'd be looked at.
Yeah.
Or reviewed, and that's fine, as you can say, making the recommendation with making the recommendation that the administration review how the utilities portion would be handled. I think that's fine.
okay, you'll help,
Sounds good. I'll amend it to add that, what you
Okay.
just said.
you'll help us word this, right, Frank?
Sure. Steve,
Now we're ready for a vote.
Yeah, let's take a vote. Uh, You have something to say, sir?
Yes, I do. I'm Ed Lee at 9300 Country Club Road. And I just don't understand why you would want to upset 4,000 tenants plus the landlords when if there's a problem, the tenant could call the landlord. And if the landlord doesn't perform on it, then he should take action. But I don't understand. Years ago, and I've been around here for many years, years ago, the citizens were proud of Piqua. Now you hear all kind of bad things. I don't know why it's that way. We want our city of Piqua to be something that we enjoy and that we love. But it isn't going that way at all. When you count 4,000 tenants, that's a good-sized chunk of people that are going to be upset with the city and the landlords. That's all I have to say.
Don't you think that those 4,000 tenants, if they get a more livable conditions, a safe condition in their property, they would be happy with that?
They won't be able to pay the rent because the rents will have to go up. So they'll be leaving town. People used to enjoy coming to Piqua, but you don't hear that today. And I think we need to have it changed.
So minimum safety standards are not important? I mean, what we're trying to do.
Hey.
If there's,
Let the man speak.
No, this is
if there's
designed
something that isn't correct, then he can take it up with the tenant, with the landlord. And if the landlord doesn't perform, then he should come to you.
Well, they have.
Now, so if there's let's say there's 150 houses in the city of Piqua out of 4,000 some that are rentals, that's not a very big chunk. But you're going to penalize over 4,000 tenants with higher rent
and the landlords with more expense. So I don't understand anything like that.
It's a minimum level of safety.
You shouldn't penalize 4,000 people for what 150 of them are doing wrong. I'm sorry.
Okay, so let's take a vote, Chris.
Who seconded the motion?
He needs a second.
Oh, I'll second.
Joe, you seconded?
I second, yes.
Okay. Ms. Brandon?
Aye.
Mr. Wilson?
Aye.
Mr. Bopp?
Aye. Okay, so at this point, the meeting is adjourned. I need a motion to adjourn the meeting.
So moved.
Second.
All in favor?
Aye.
Aye.
When we were talking about looking